Arbitration and litigation are two different ways to resolve conflicts and disputes in the context of an ERP software contract. What are the differences and which one is right for you? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For the past 20 years, I've drafted and negotiated ERP-related contracts and litigated ERP failures in courts across the country. So certainly the trend in the contracts that we negotiate and the contracts we litigate is arbitration. And I think there is good reason for that. Arbitration can be less expensive than litigation. Arbitration is, for the most part, I think it's less complicated than litigation. And the reason for that really is discovery is abbreviated in arbitration. There are a limited number of depositions that are allowed, if at all. And some arbitrators don't want any depositions at all. There's less discovery devices that can be utilized. For example, requests for admissions are often not utilized in arbitration. Interrogatories, I think there's going to be a subset of interrogatories that you would be able to issue to the other side. And so it's certainly a more compact version of litigation to some extent. And because of that, the process to resolution can be quicker in an arbitration. I think one of the main advantages of arbitration, if you do it right, and we'll talk about that in a second here, is that you have the ability to pick your arbitrator. And you get a sheet with available arbitrators for the date ranges that you want, and you can go through their resumes, see what kind of cases they've arbitrated in the past, look at what kind of experience they have, what kind of cases that they maybe dealt with when they were in private practice or when they were judges. And so you're able to vet somebody in a way that you would not be able to if you were in litigation. You don't get to vet the judge. It's randomly assigned to you, and then you've got to make the best out of it during the course of the litigation. So I think certainly that it can be beneficial to you. You can get somebody that's more tailored to your case, that has a level of experience that is applicable to the technology that is at issue. Some of the disadvantages, though, and I think there are many, is while it can be cheaper than litigation, you've got to understand that the filing fees associated with getting your demand for arbitration on file, getting your arbitrator once you've picked one, those fees are incredibly expensive. At the front end, filing a lawsuit in federal court, I think, is $450 or something like that. Certainly you've got to draft a complaint and do other associated things, but in general, arbitration in the front end, I think, is going to be expensive. You will typically share the cost associated with the arbitrator with the other side, and the arbitrator is going to bill you at an hourly rate associated with the amount of time that they're investing in the case. You're going to go before them to resolve discovery disputes, potentially motions to compel. Maybe there might be a motion to dismiss depending on how the arbitrator is managing the process. But the bulk of the cost really is going to be getting that arbitrator retained, and then paying him for the arbitration hearing, reading the pre-arbitration briefs, any post-arbitration briefing, and then he's got to write an order, he or she has got to write an order detailing their view of the case and who's going to win and who's going to lose, and that's incredibly time intensive, and that's all out-of-pocket expense, where in litigation that's what the judge does and that is their job. One of the other disadvantages of arbitration over litigation is, I think, really the outcome can be incredibly uncertain. And while you've done a good job on the front end of vetting an arbitrator, getting the experience that you think is necessary for your case, you never know what you're getting. And in my experience, a lot of times you're getting attorneys that are in the fourth quarter of their career, they're at the end of their career, they're part-time arbitrators, maybe the experience they have with the technology is dated, they haven't practiced law full-time for many, many years, or maybe they're semi-retired or retired. Sometimes you're going to get a retired judge, and maybe you'll fare better with that. You can also have a panel of arbitrators. Maybe you've got 3, maybe you've got 2, maybe you only have 1. So the structure can be different. The result of that really can be disastrous. If you get a bad arbitrator, and especially if you only have 1, you've got to live with that decision. The reality is, an arbitration order, if you will, is not something that's easy to appeal. And a final order of an arbitrator carries a lot of weight. and the other side can go in court and enforce it. And if you're not happy with the result, you've got to find a way or a means to be able to argue to a judge that it was improper. And that's incredibly difficult to do, almost impossible in my experience. And so I think, if you get, what we would kind of term, rough justice from an arbitrator that doesn't really understand the issues, didn't read the contract carefully, maybe wasn't paying attention during the hearing, which is essentially like a trial, you could be in for quite a shock, and these arbitration awards are going to be enforceable. They could be detrimental, and they could cost you hundreds of thousands of dollars. And so, arbitration does have a lot of pitfalls. And, you contrast that with litigation. Yeah, litigation is expensive, and it can be much more expensive than arbitration, but not always. You get an aggressive opposing counsel in arbitration and an arbitrator that's not really managing the process carefully. That thing can spiral out of control, and it can be just as expensive as a piece of federal court litigation. So you're not guaranteed as to what you're going to get. I think on the litigation side, it's governed by rules of civil procedure. In federal court, they're the federal rules of civil procedure. So everybody has an understanding of what the rules are, what is permissible, what isn't permissible. You get a bad ruling from a judge, you can get a request for reconsideration. So the judge, you tell the judge there's a problem. If he's not going to rule in your favor after that, you can appeal it. So there's built-in mechanisms that I think are desirable in the litigation context. The judges are generally very good. They're very experienced. They've seen cases in the software arena before. They're going to understand the issues generally. They're going to take their time. There's going to be an extensive body of case law that's going to be applicable to the dispute that they should be familiar with. Whereas an arbitrator, they may not have the substantive experience in this area, and they could be coming to these cases for the first time. And what's worse, they may not have an understanding of the technology and the nuances associated with an ERP failure. And I think that in and of itself is incredibly problematic and can lead to wildly unpredictable results. And so I think arbitration is certainly not preferable necessarily. I mean, I think it can be, but if you're going to arbitrate your disputes, or you're being required to arbitrate your disputes, I think it's incumbent upon you during that contract negotiation process to really try to leverage the plus sides of arbitration as much as you can. You want to make sure that these arbitrators are required to have relevant experience. Ideally, you've got a panel of arbitrators that's going to be deciding the case. There's a process. You pick a good forum. There's AAA. There's JAMS. There are different forums you can be before, and some of them are better than others. I think you want to maximize the benefits while minimizing the liabilities associated with arbitration. And I think if you do those things, then you're going to come out of that with a good contract that's going to serve you well, regardless of whether you're going to litigate disputes or arbitrate disputes. And if you've negotiated that contract tightly, hopefully you don't have a reason to arbitrate or litigate anything. If you have any questions about anything that we've discussed in this video today, please feel free to reach out to us at taftlaw.com. We'd love to talk to you, point you in the right direction, and answer your questions. Thank you.